Here at Charlie Crime Buster, we welcome comments, suggestions, opinions, and whether you agree or disagree with our view on a topic, we still want to hear from you. Reach out with a shout-out. Email Charlie at charliecrimebuster@gmail.com. That's charliecrimebuster@gmail.com. Or you can call or text us at 407-917-2211. That's 407-917-2211. And we'd like to thank our sponsor, PeacemakerNetwork.com, and also thank those of you who already support our podcast. Did you know that your donations not only help with this podcast, but also support the brave men and women, first responders, law enforcement, correction officers, security personnel, and our military? You too can donate, as well as become a monthly badge member. That's BADGE member by simply subscribing to PeacemakerNetwork.com. That's PeacemakerNetwork.com. And if you're a true crime junkie, we would like to encourage you to binge-cast by listening to our podcasts located on many of the popular podcast platforms. Simply search for Charlie Crime Buster, or you can ask your smart speaker to play Charlie Crime Buster. But since you're streaming us here on YouTube tonight, simply click on the subscribe button and you'll be notified each time we drop a new episode. So please do us that huge favor and press that subscribe button right now. And we thank you. The views and opinions expressed in this presentation are solely those of the individuals interviewed or participating and do not represent those of Charlie Crime Buster nor Peacemaker Network. All individuals described or mentioned in the presentation should be considered innocent until found guilty in a court of law. This presentation contains subject matter such as violence and graphic descriptions, which may not be suitable for all audiences. Listener and viewer discretion is advised.
We're in the second trial of Karen Reed. And there are, again, some explosive moments that we're going to cover as we talk about last podcast that was released by Charlie Crime Buster in our podcast, The Karen Reed Second Trial. So, James, we got a whole lot to talk about tonight.
We certainly do, Charlie. We certainly do. There's a lot.
Yes, and you know, this trial is ongoing right now, and boy, today was a day of just intense cross-examination. And we'll tell them all about that during our next release coming up over the weekend. But right now, we're going to take some time and talk about the last episode that we dropped.
So about this second trial, there were some things from the first trial. And how do you think that this trial is impacting those that already heard about the first trial?
Well, you know, a lot of times what I've been watching is not only the trial itself and the cross-examination, direct examination, and watching all the activity in the court, but it's been really interesting to me to see some of the comments from other people that are watching it, and particularly people who have watched the first trial and watching this one as well. And you know, what I've kind of come to realize and think that is probably true, and maybe it's just like human nature, you know, I think that in the first trial, if you thought that Karen Reed was guilty without a reasonable doubt, then I think that you're thinking that in this trial. And if you thought that it wasn't proven without a reasonable doubt, I think you're going to think the same thing in this one. In fact, I think that when it's human nature. When we've already kind of made up our mind in the first trial, we're probably going to zero in on that reinforces what we believe, right?
Exactly. Yeah,
so,
you already formed the bias.
If we're really pro-defense, then when the defense knocks a home run, boy, we're going to be cheering and saying, yeah, boy, that's right. And when the prosecution comes by, we're going to say, oh, man, he's doing it wrong. You know, this is, he's turning people off. So I think the only difference that I have found in looking at people who had observed the first trial to this one is that most of the stuff that I've been reviewing, most of the stuff that I've been seeing, that just about, I would say 75% plus agree that Hank Brennan is doing a better job with the prosecution than the previous district attorney and the previous trial. So I think the prosecution is doing better in that it's a lot tighter. He's going about the witnesses in a very different way than the first time. And I think that the prosecution is coming across a little better, but I still think that there's there's a whole lot of areas where the defense is plugging it with ways that people could attach to reasonable doubt, and we'll be talking about some of those ways right now tonight.
That's right. That's right. Just as a side note, if I were a juror in the first trial and listening to this second trial, I wonder what would be going through my mind right now. The evidence
Yeah,
that was now,
that's good thinking because there is some little there's added evidence
yeah,
in this
yeah,
trial. Yeah.
right. Well, did Whiffen, the state's witness, prove that John O'Keefe did not go into the house at 34 Fairview?
Well, that's why he was called to do.
Hmm.
That's why the state put him on. He is an expert. And he talked about, the phone as it moved around that morning,
Hmm.
there in the yard and all around. And he talked about how many steps was taken and this sort of thing. But if you heard him on the direct, then you might be thinking to yourself, well, I think he may be proven that he never got in the house. But then the cross examination takes place and they point out that as many steps that they said, his expert said in this particular testimony, that same number of steps would also lead him into the house. So he
Right.
says basically, he gets him on cross examination and he gets that Perry Mason moment that we call, where
Hmm.
he basically said, so it is possible that John O'Keefe actually based on what you're showing us, that he could have been in the house. And
Right.
the expert
Right.
had to say, yes, he could have been.
Yeah.
So
This.
so I'm not sure that this expert really knocked the home run. I think maybe the defense turned around and punched some serious reasonable doubt in there.
Well, just the fact that he demonstrated that the signal was weaker
Yes,
at that location in certain
yes,
times, which would
yes.
indicate you're in an enclosure. He even mentioned
Yeah,
that.
that would be another thing that could see,
Yeah.
what else happened was the fact that talked about, that there was a closure, Now
Hmm.
maybe it could be in a pocket, maybe it could be, but it wasn't an enclosure all the time. It kind of moved around a little bit, and so then he said that means that if it's in that closure, that could mean that it was in the house, right? And then again,
Yep.
comes back that idea that so I'm thinking that this particular part of the expert, I don't think you could say that they solidified it for the prosecution. I think that again there is a reasonable doubt,
Hmm.
that people could say, well, he could be in a house and he may not be in a house.
Well, what else did this witness have to concede to the defense?
Well, he did have to concede to the fact that that cover, was involved in there, and the other thing too is I thought that. I tell you one thing. I I don't think that I would envy anybody who would have to stand up to Alan Jackson's cross examination and the other attorney as well. I mean, the
Right.
defense team, David, the defense team is doing an outstanding job
They are.
of cross examination. And, you can tell they have thought it out. They've got all their material there. They have the impeachment material
Right.
to, impeach these witnesses. And I think that basically when it comes down to it, he had to concede the fact that everything that he brought to the table, it does, it does have some tendency to say that he was out in the yard, but there is the possibility that he
Hmm.
could have been in the house based on the information that they were testifying to.
Right. Well, what did the expert leave out of his presentation?
I thought that this was really, and I don't know how the jury sees it. None of us really know. We really don't know what's going to happen because the jury is going to be the one that has the final say in this, regardless of what I think or you think or anybody out there thinks. The jury is going to make that final determination. But I think that they made a real mistake, because in one of the presentations there was a PowerPoint, and that PowerPoint was showing various radiuses where that phone could be throughout that night, and you saw some of them with little circles in the yard and this sort of thing. But there was one slide that he left out of the presentation.
Hmm.
And of course, the defense, they've already had discovery. They already
Yep.
recognize that that slide was not presented.
Right.
And so then the defense gets up and says, "Hey, how about this one you left out?" And in
Hmm.
that one that he left out, a big old circle enclosed that house to show that that device could have been
Right.
in that house by that circle. And I think that what is was even more disturbing, I guess, or more impactful. I'll have to word the impactful was the fact that some in the jury could think, "Hey, they're trying to hide this from us," you know.
Exactly. Yep.
Yeah, they left that one out. Why did they leave that one out?
Yeah.
And I do know this that juries do not like it
No, they
when they
don't.
think somebody's trying to hide something from them. And I don't think anybody does. You know,
No. No.
it gives the impression that you have to be deceitful
Right.
and you're not being truthful and forthright in what you're doing. So I think that this was a really critical mistake by Brennan to allow this to come before the jury to where they held that back. They'd been much better off if they had just went ahead and showed the slide and then said, well, there's other data that says, when it was at its peak that it wasn't there. They could have explained it away, but
Right.
now any explaining away they do is overshadowed by the fact that they left it out.
Right. Right. Well, we have an interesting. We're going to take a little bit of break here, and you have an interesting story to share with us about a crazy crook,
Our crazy
and
crook, right? Yeah.
not a Florida man this time.
Ah, you got that right.
I
Yeah, it's
did. Yeah.
hey, ladies and gentlemen, this time this crazy crook story today is not a Florida man. But guess what? It's a Florida woman. We got a
Yeah.
lot of those down here too, you know.
We
A lot
do.
of Florida women. I think the last two, in fact, we've brought
Yeah.
have been women, you know. So this was a very well. It's a crazy crook story, and it's somewhat humorous in that that she was just crazy to do this, but it was also a very sad one, I thought, because this is a lady who actually wanted to get rid of her 3 year old child. And so the way she went about it is that she went online and she found this website that said Hitman for Hire. Now, this wasn't on the dark web, by the way. This is just out there. It was just a joke, Hitman for Hire.
Oh
But
boy.
she thought it was real, and so she went ahead and, and tried to line up a hitman to take care of her 3 year old child. And,
Wow.
even to the point that she gave them the safe word that the child is supposed to use and that sort of thing. So
Yeah.
it's sad that somebody would stoop that low, but it's crazy that you would think that you could just go on the internet and boom, right there, just go ahead and hire a hitman like you hire a consultant or you
Right.
hire somebody to come take care of your car or you hire somebody to come and take care of your line. I'm just going to get online and find out where I'm finding a hitman.
Right.
But
Right.
amazing about this, James, is that she's not the only one. There's been over 30 people that have been arrested who have actually applied to this hitman for hire, and so this that turned
Wow.
out to be a joke actually has become an instrument that law enforcement has been able to use to be able, and I think this is really fantastic because the
Brilliant.
fact that they are stopping
Yeah.
this from going further, because if that wasn't there, she may have tried to find another way to get rid of her child,
Right.
but because that was there, then it was a trick, and she bit it hook, line, and sinker, and so indeed she was. I think we all agree she was a crazy crook for sure.
She was. She was. Well, back to our second trial of Karen Reed. What was this about there was a battery in JJ's phone. Share a little bit
Well,
about
yeah,
that.
of course we all have batteries in our phones.
Yeah. Yeah.
This was actually alluded to in the opening, and so I was thinking that I don't recall in the first trial that there was much said about the battery and about how it relates to the environment.
Hmm.
And so when this was dropped by Brennan in his opening statement, I thought, this might just take it over the edge. This might be able to get them beyond the reasonable doubt into another thing because it's scientific material, and that certainly
Accurate.
resonates and
Yep.
in something like this. But I got to tell you, I don't know that they picked the exact right uh, specialist and expert to do this, because when he was on cross-examination and he talked about doing testing and this sort of thing,
Hmm.
under cross-examination they said, "Well, do you know what the temperature was that night here in Canton?" And he didn't even know that. I mean, you would think
Yeah.
that if you're going to test something,
Yep.
you would test it according to what the temperature is, you know?
Exactly.
And then on top of that, one of his tests of taking the phone out of the code in 15 minutes in like temperature, the test dropped 31 degrees, the test battery in 15 minutes.
Yep.
But O'Keefe's phone, and the same 15 minutes, it only decreased 11 degrees.
Exactly.
So if anything, again, it goes back to kind of what happened with the other part with trying to find a location. I'm just thinking that that the scientific approach that the prosecution is following. I think it's brilliant. I think it would be brilliant to be able to bring the battery in and show that. I think it's brilliant to be able to show the location. But the only problem is it's not standing up to cross examination.
Exactly. Yep.
And it's great material, and I think that we're going to see a lot more of this as they perfect these studies. I think it's going to change a lot of things. There's a couple things that are happening in this trial that I think will change the way some trials are handled and the way some attorneys handle it. And so I think there was a great opportunity to use this battery to really bring it home. It was a great opportunity to use the location of the phone, but I think the way that that both of these experts uh, withheld the cross examination, I don't think they were very strong at all, and I think the cross examination uh, gathered a lot of points in poking holes through this so-called scientific method.
Well, I also found it
Well, what do you
interesting.
think? You're pretty good at tech stuff. You're better than I am. What do you think about it?
Well, what also brought out in the trial was the fact that there was 37 steps.
Yeah.
When in fact it's like 84 feet from one particular place,
Mm-hmm.
and you took
It,
a regular
take
stride.
it,
You
take it,
can't.
yeah, take it right into the home.
Yeah, yeah. And so
So,
they're
you,
poking holes in it left and
yeah,
right. You know.
you'd have to think that I would think that you're thinking through your case, right?
Yep.
And you say, okay, we're going to mention that there's 37 snaps there. You have to think that they themselves would have thought, well, whoa, wait a minute. Why am I going to present this? Because that'd bring it right into the house. I mean, it
Exactly.
played right into the hand of the defense.
It did. It
I mean,
did.
it was like it was like throwing them a softball that they could just knock out of the park, right?
Exactly.
I mean
Exactly.
that's the way I saw that, and I think in both the battery and I thought the at the beginning, boy, I got to say again, I thought this is going to be phenomenal that they're going to be able to show that battery, and they're going to be able to show
Hmm.
based on the battery that he was outside all that time, but.
Didn't work out.
It just it didn't meet the test. I'm not saying that proves that he was in the house, but I'm also saying that it doesn't say that there's no possibility that he was in the house.
Yeah. Well, segueing to what we were talking about being out in the cold, there was that infamous text. And so where are we with about that text that says how long to die in the cold?
Yeah, yeah, and you get back to it. Even if you could show the battery, we do know that he was out in the cold
Hmm.
for a period of time. We don't know exactly what that time is, according to whether you believe the prosecution or whether you believe the defense's theory in it. But the big text that has been I think everybody's been waiting for, particularly those of us who watched the first trial, is to see how they're going to handle this infamous, I call it the infamous text, because the defense says that text was actually made at 2:27 a.m. in the morning, and the prosecution says no, no, no. They're coming back and saying that 2:27 in the morning, maybe that tab was opened,
Hmm.
but the text wasn't really rendered to 6 something in the morning, and there was there was a lot more, I think, credible evidence or credible presentation of information that could easily make somebody say, "Yeah, I think this did happen at 6:23 in the morning." But then when it comes back down to it, there's a law enforcement search that they have a report for, and
Hmm.
it's right there, and it says, "No, this happened at 2:27 in the morning."
Right.
So, I mean, I tend to believe maybe it happened later, but if you were to say, can you say it without any reasonable doubt? No, I couldn't say it without any reasonable doubt. You
Exactly.
know,
Yeah.
because it could have possibly happened at 6:23 in the morning. I think the thing that a lot of people are wondering, maybe as lay people, when it comes to uh, talking about data with cell phones and code and all this sort of thing, we as lay people, I think that what I'm thinking, probably what everybody else is thinking, if they really want to prove something, why don't they get the people from Apple in here? I mean,
Right.
this is an
Right.
iPhone, right?
Exactly.
I know that people are saying, because I've heard comments from people that are watching the trial saying, this is an Apple phone. Rather than bring these people from this other company in, why don't they bring Apple experts in?
Right. Right.
And I can't help but wonder that, wonder why, but maybe that Apple, would stand up under privacy and make a big deal. I don't know, but the people are wondering, if the Apple phone says, according to it, it happened at 2:27 in the morning. I think people are going to, line up with that. So I still think that when it gets to the end of this trial, I don't know that the jury unanimously will come down on one side or the other as when that text came. I think some will say no. I think it was 6 something in the morning, and I think some may say that no. I think it was 2:27. And if that happens, we're going to look at either not guilty or a hung jury probably
Hung
again.
jury. Yep.
You know?
Yep.
Yeah.
Well, how did the defense handle McCabe's statement, I hit him, I hit him? Because that came up.
Yeah, and again, and we knew that this was going to be big because again, Brennan in his opening statements, right out of the barrel, he
Hmm.
said, "I hit him, I hit him, I hit him, I hit him." And they're making a lot of hay with the statements that Karen, according to some people, said, "I hit him." Then, of course, there are other people said that, well, no, she said, "Did I hit him? Did I hit him?" And all of that. I think that. Jackson did the best he possibly could with that because I think it is and the fact that she said I hit him, I don't know that if she did say it that absolutely meant that she did it because I think she was confused that morning. She didn't really
Well,
know what happened.
well,
But
I'm thinking of it from this perspective.
yeah,
What about inflection? You can say I hit him, making a statement, or you can say I hit him? Question mark.
exactly,
It could be
exactly.
inflection. She may have said
Yeah,
it, I hit him,
yeah, yeah.
in a question.
And there are other people that also testified. She said, "Did I hit him? Did
Hmm.
I hit him?" So
Right.
I mean, she could have said both, could have said it in that way. But I think and I do think it was damaging to the defense.
Right.
However, I think Jackson did the best that he possibly could, and I thought this was a great move. In the cross examination, he had this document, 200 pages of her sworn testimony before the grand jury. 200 pages.
Hmm.
And he brought it to her and said, "Tell me one time when you were talking to the grand jury, and this is very, very critical, all of this is,
Hmm.
and yet you did not one time mention that she said, 'I hit him, I hit him,
Exactly.
I hit him.'"
Exactly.
So I thought that was, that was a really smart move by Jackson to bring that to it. You're saying that this is so important and it had such an imprint upon you,
Right.
but you did not even say that one time to the grand jury when you were testifying under oath about that.
Well,
And
speaking of that, what are other ways the defense sought to impeach McCabe on the stand?
well, they were. I thought this was fascinating, and I will say that McCabe, in looking at her first trial and standing up to the pressure of cross examination versus this one, I think she stood much stronger this time. I thought she was a better witness this time. Maybe practice makes perfect, right?
Yeah.
And she came across softer, and I think she was really good. But there were some really gotcha moments. One of the things that I thought she did not handle very well was she had they brought up the fact that and I think probably most of the people that are out there listening know about this, but they brought out the fact that there was another agency that was brought in to investigate this.
Right.
And you and I know that it was the FBI, the federal government, because they
Yep.
thought there might be some police corruption. So they were investigating this whole case.
Correct.
And so they came to visit her and to interview her. And they told her that unlike a regular police officer, if you lie to an FBI agent, it's a felony.
Hmm.
You can't
Yeah.
lie to him.
Right.
And so he said, they asked you who you called before they came in to talk to you when we said we wanted to talk to you. And so then she mentioned her husband and somebody else and somebody else. But guess what? She left out somebody, James. Again,
Uh-oh.
that deceitful of leaving out. She
Yep.
left out the fact that she called her
Hmm.
sister, who is the wife, you know,
Right.
of Brian Albert,
Brian
who
Albert.
where they
Exactly.
alleged that, the defense alleged that he got beat up in that house.
Right.
So, I mean, he caught her right there, and in that, I mean, it was very obvious. She said, "Oh, I just forgot." Now, do you really believe that you would forget
Your sister?
that you called your sister right
Yeah.
before these folks came in?
Right.
I think all of us were thinking, well, no, no, you knew it. You were just trying to protect your sister. You were just trying to
Exactly.
protect the fact that you called him. You didn't want to call attention to the fact that you called them. And then, uh, Jackson brought up about, well, the reason you're doing this, everybody's trying to get their story straight. No, 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 we're not trying to get our story straight. We're just saying, hey, did they come to you yet? Did you come to you? And you and I both know that human
Exactly.
nature is, what did you say to him?
Yep.
And here's what I'm going to say to him. And
Yep.
now let's get our story straight. Let's be together on this.
Yep.
It's unbelievable that she didn't do that. And I think she'd been better to say, yeah, we talked about it.
Yeah. Yeah.
Yeah,
She did. She
I called my sister. There's nothing wrong with me calling my sister. I can call anybody I want to.
she didn't want to implicate her. I could tell that.
No, no,
Yeah.
but she
Yeah.
she she fought that. She became so defensive about it
She did.
that it made her look guilty about it.
Exactly.
And so I think that
Exactly.
was another way that they handled that.
So what was the possible game changer moment in this week's trial, you think?
I think in last week's trial that the podcast covered, I think the game changer to me was when they had the hearing to see whether the archive witnesses would be excluded from the trial.
Hmm.
Because of the fact that they had tied up with the federal government before, and they weren't able to get all the discovery items to the judge that the judge had requested for this
Hmm.
sort of thing, and they're going to have a new report that come out that they wouldn't have time to really get ready to cross examination, and Brendan, boy, he fought hard to get them excluded. I mean, he
Hmm.
he
Hmm.
really fought hard. James, I think that if the judge had said, she was leaning toward it because she really was upset about it, if she had have excluded the archive witnesses who we haven't heard from yet,
Hmm.
I believe that could be a game changer because I think you and I agreed last week
Yep.
that I thought the most important evidence to support the defense was the archive witnesses. These are accident reconstruction experts. They're far more trained and educated and have far more credentials than regular police officers do.
Right. Right.
And I've gone to school for crash accident reconstructions, and police officers know a whole lot about it, but we're not as we're not as scholared and knowledgeable as force and motion and impact and all these things. These guys are. I mean, they're right on top of it. Now,
Mathematicians.
whether yeah, whether they're right in what they're saying or not, I mean, that's the jury's going to have to weigh both of these experts because there's going to be another expert that says the opposite.
Right.
But I don't think any expert they bring to the table will have the credentials that these guys have. So, don't
No.
you think it would have been a game changer if she had said no? Our
Yeah.
guy
Oh,
could not
definitely.
testify. It would make, I think, a big difference in this case.
Definitely.
Whether it would overcome all the reasonable doubt or not, I don't know. But I guarantee you that the thing that took me over the top, not to come to the conclusion that he was beat up in the house, but to come to the conclusion that there's reasonable doubt for me,
Right. Right.
was the fact of the archive guy saying, "Hey, that his injuries are not consistent with impact of a vehicle," and they study these things all the time.
That's right.
They're the top of the level. They have to be. That's who the federal government hired for it.
Right. Right.
And they have the best experts.
That's
With
right.
it. So I think that would have been the game changer. What about you?
Well, I think that the judge did not want to have to deal with an appeal. So therefore, by
Exactly. Yeah.
allowing them to testify would, avoid an appeal.
But now you could tell. You could tell she really didn't want to. She didn't really want to do
No,
it,
she
but
didn't
she
want
she
to.
just she just knew she had to
Yeah, she knows either
because
that
of the
or
appeal, and
yeah,
also that this lady is on trial for her life, and she deserves the benefit of the doubt, and she deserves the best witnesses that they can muster for her,
that's right.
because it's up to the prosecution has the burden of proof,
That's right.
and to take that away from the defense, I think it would certainly set up an appeal, no doubt about that,
Oh,
if
no
if,
doubt.
if it went the other way, and I think she had to let him. But I was wondering which way she was going because a lot of people have said, and I don't know whether you think it or not, but to me, it appears that the judge is really leaning toward supporting the prosecution. Now she's not way out there, where it's really noticeable, but seems like in all of her rulings,
Hmm.
most of them have been in support of the prosecution. So
Yeah.
it was a little bit of surprise to me that she did not go ahead and say, "Hey, no, I'm going to exclude him." I thought, boy, if that does it though, that would be a game changer. But it's
Oh,
not.
definitely.
They're going to be back, and folks, we're going to hear from him. We're going to hear from him, and something else, James. It's going to be some new stuff this time because according to what I've reviewed, they also have in this new report a rebuttal against who the state's bringing on to
Right.
do their witness. So they're already prepared to have a rebuttal to whatever the state throws at them with
Yep.
that reconstruction part of this, which I think is just really critical. I mean, we can all think somebody's lying or somebody's not lying, this sort of thing, but when you get down to the scientific part of it, force and motion and what really happened, whether he was hit or not hit, I think that's going to have a whole heavy weight to the way the jury goes.
Oh, definitely. Well, I know that this week I've been kind of keeping tabs on what's being disclosed and uh, who's testifying, um, and who's doing direct and who's doing cross. So, um,
Yeah, and isn't it funny uh, and we'll give folks I guess preview of what's coming up, but it's kind of interesting to watch how they're trying to step around Michael Proctor, isn't it?
right.
And every time they do that, here's the defense coming right back. Who did you supervise? Michael Proctor.
Yeah.
Who was in charge of this case? Michael Proctor.
Uh-huh.
Who gathered this evidence? Michael Proctor. I
Yep.
mean, there's constantly, as much as the prosecution's trying to get away from the disgraced cop who was fired,
Uh-huh.
and who was totally inappropriate in this particular case. As much as they're trying to get away from it, the defense just keeps coming back. Michael Proctor, Michael
That's right.
Proctor.
That's right.
So, do you think that if Brennan doesn't call Michael Proctor, do you think that Jackson will call Michael Proctor?
It's very possible. Yeah. Because I think he wants to to get his side of it to see exactly how much he will lie on the stand.
Well, you can already see, he's already talking about the possibility of bias in
Uh-huh.
the case,
Exactly.
and the guy that ties that bias to the case is none other than Michael Proctor. I mean,
That's right.
when you get up and say the nasty things that he said about Karen Reed and that text that he let out, we saw some of that today, where they talked
Yeah.
about that his supervisor actually received that text and the supervisor actually was disciplined. The guy that was on the stand today
Yeah.
actually lost 5 vacation days
Yep.
because he did not supervise Michael Proctor the way that he should have supervised him and how he went on with that. So, but we'll get on all that next week. Got a lot more stuff to go, don't we?
Yeah,
It's
there's a
like
whole
a
bunch.
8 weeks, and this is what, our third week right now.
Yeah, yeah. We thought it'd
Yeah,
be over by now, right?
yeah. I think
So we
you
did think it
know,
anyway.
yeah. Well, this guy, they were cross-examining today. He's going to be back tomorrow for more of it.
It was interesting to listen to Gallagher, retired Officer Gallagher,
Yeah.
this week, and the things that he had to disclose. Did you search the house? No. Did you search the
Oh,
basement?
yeah.
No.
Boy, he kept trying to talk around it, though, didn't he?
Yeah,
I mean,
he said he didn't know how the cases were assigned,
yeah,
knowing
yeah,
full well
yeah,
that it was Michael
yeah.
Proctor.
Oh, yeah.
Yeah.
I mean, the
Uh,
the way he went about that actually made him look really bad.
it did. It
He
did.
should have just come out and said,
Yeah.
he was the head
Yeah.
guy, and he made some mistakes, but it really didn't affect the evidence.
Well, it's that blue that code
Uh,
that code that blue code that they take on.
yeah, yeah. Well, I think they're, it'd be interesting to me that if Brennan does, if he does call him, how would he treat Proctor?
Yeah. Yeah.
Because I think even Brennan might be, come off real negative to Proctor because I don't think anybody can support the actions of Michael Proctor in this investigation.
Yeah. I mean, but then as a juror, how credible anything that he says, how credible is it?
Yeah,
If all the evidence that he presented fell apart in the first trial,
yeah,
because I'm sure
and that's
Jackson will point that out.
I tell you, he was definitely a gift to the defense.
Yeah,
If
definitely.
you take Michael Proctor out of this whole setting, and we might have a whole different ball game.
That's right.
So until next time, this is Charlie Crimebuster reminding you, stay safe, stay alert. Yep, for the life you save, it could be your very own.
You have been listening to Charlie Crimebuster. You can find additional podcasts at charliecrimebuster.com. You can also support our first responders, military, and law enforcement communities at peacemakernetwork.com, or subscribe to our YouTube channel using tag @CharlieCrimebuster. Even visit our Facebook page, facebook.com/CharlieCrimebuster. Or if you would like to make suggestions for future podcasts, please send your ideas to charliecrimebuster@gmail.com. That's charliecrimebuster@gmail.com. Thank you for joining us today, and we hope that you will join us next week for another exciting crime story with Charlie Crimebuster.